Attention gun owners and home defenders. Starting July 2026, one court mistake could turn your legal carry into charges. Last week, a 72-year-old named Patricia in Seattle faced a $9,145 legal shock. She thought a paperwork order ended months ago and didn't matter anymore. Her stomach dropped when her attorney said possession could mean prison time. If you own firearms, this new court shift can hit you fast and quietly. Stop for 5 seconds. If you're not subscribed, you're gambling with your legal and financial future. The next update I publish could save you serious money and stress, but you won't see it in time unless you're subscribed. Click subscribe now, then stay with me through the simple steps. Here's the real problem nobody explains in plain English. The Supreme Court doesn't only change laws by striking one down, it also changes how judges measure your rights in lower courts. When that measuring tool changes, outcomes change even with the same facts. That's why headlines feel confusing, dramatic, and sometimes totally misleading. You keep hearing big win or big loss like it's one clean scoreboard, but real-life gun cases don't work like a single final buzzer. Most battles are decided by the test a judge is required to use, and that test is tightening right now, in ways people miss. Your rights didn't vanish overnight, but your risk can change overnight. One big shift is how courts compare today's rules to older ones. Some judges used to demand an exact historical match for modern restrictions. Now the court is signaling that close enough comparisons can be acceptable. That sounds small, but it can widen what governments argue is allowed. It also creates new openings to challenge broad bans that snag peaceful people. Another shift is about agencies and the words inside laws. When Congress writes a law, an agency can't rewrite it by definition tricks. If agencies could stretch words freely, your lawful gear could become contraband. That's how people become criminals without doing anything new. And that's what should scare you, even if you hate certain accessories. Let me tell you about Thomas. He's 74 years old and lives in Denver, Colorado. He's a careful hunter who logs every purchase and stores receipts. One afternoon, he got a certified letter about a compliance change. The letter warned about a $6,180 penalty if he didn't respond. 2 days later, Thomas called the number listed on the notice. A bored voice told him a rule, updated the category of his item. Thomas felt heat rise in his face because he bought it legally. He asked how a rule could change the meaning of a law. They told him, "That's just how it is," then ended the call. Then things escalated fast, the way they always do. A friend sent him a screenshot of a new enforcement deadline rumor. Thomas panicked and drove to a local shop for answers. The clerk said, "Don't guess," and urged him to get real legal help. Thomas heard estimates of $12,740 in defense costs if something went wrong. That's when fear turned into anger, because none of this felt fair. Thomas chose a safer path, even though it wasn't cheap. He booked a short consult with a local attorney for $425. The attorney explained the difference between a law's text and an agency rule. Thomas learned he had options and didn't need to rush blindly. He avoided a bad surrender decision and saved about $8,210 in wasted actions. Now he tells everyone, don't let panic make your choices for you. Now let's talk about what frustrates me the most. Regular people try to follow rules, but rules keep shifting under them. You can pass checks, store safely, and still get trapped by technical wording. And the system rarely warns you in a clear, personal way. It expects you to monitor updates like it's your full-time job. Here's what makes me angry on your behalf. Some officials talk like confusion is your fault for not keeping up, but criminal law should never be a guessing game. If a definition is fuzzy, enforcement becomes a trap instead of public safety. And that's why Supreme Court signals about text and definitions matter. Let me tell you about Barbara. She is 69 years old and lives in Charlotte, North Carolina. She carries for protection after a break-in scared her years ago. She also went through a messy breakup that ended with court paperwork. She assumed it was temporary drama and would fade out quietly. 3 months later, Barbara tried to buy a replacement holster at a show. A vendor asked routine questions, and she mentioned an old civil order. The vendor went silent and told her to talk to a lawyer immediately. Barbara's hand shook because she thought the order was harmless. That night, she couldn't sleep, replaying every detail of that hearing. Then the complication hit, and it hit hard. Barbara found a copy of the order and noticed a threat-finding line. She didn't remember that phrase being explained to her at all. A friend warned her that possession could trigger serious charges. Barbara heard numbers like $18,950 for a full defense through trial. She felt trapped between fear, shame, and the urge to ignore everything. Barbara didn't ignore it, and that decision probably saved her life. She went to the courthouse clerk and asked for every related document. She found missing notices, confusing checkboxes, and unclear hearing records. With counsel, she filed to clarify and modify the order's terms. Her total cost was $2,740, far less than catastrophic legal exposure. Now she keeps a folder labeled Proof and checks it twice a year. Quick pause. What state are you watching from right now? Drop your state name in the comments because laws change by state. Your comment also helps this reach people who need it. Comment your state below so I know what to cover next. You're starting to see the pattern, and it isn't about politics. It's about process, paperwork, and the exact words that control your life. One judge focuses on history comparisons, another focuses on statutory text. If you don't know which battlefield you're on, you can't defend yourself, and the wrong assumption can cost you years you'll never get back. So what's the new reality you should plan for? Courts are drawing lines around who can be disarmed and why. They're looking closely at whether there was a real hearing and findings. They're also asking whether limits are temporary, targeted, and tied to safety. That can protect peaceful owners, but it can also validate narrow restrictions. It also means facts matter more than you want them to. The exact phrasing on an order matters more than your memory of it. The date you were served matters more than what your ex told you. Whether you had a chance to respond matters more than the rumors online. That's why you must treat paperwork like a loaded chamber, not a nuisance. Let me tell you about William. He's 71 years old and lives in Portland, Oregon. He loves building projects and enjoys tinkering with legal hobby kits. He ordered a parts package online after watching a flashy ad video. The checkout page promised easy assembly, and that promise hooked him. A week later, William noticed a new policy notice from the seller. It said the kit may be treated differently depending on included components. William felt confused and embarrassed because he thought it was straightforward. He called customer support, and they sounded nervous and scripted. They offered store credit, but wouldn't answer direct legal questions. Then a worse twist showed up, and it raised the stakes. A local range buddy warned him that readily convertible language is dangerous. William realized the same kit could be seen as a regulated item. He imagined a traffic stop leading to questions he couldn't answer clearly. He heard a retired officer say, "Ambiguity is where prosecutors live." William felt anger because honest people shouldn't fear unclear categories. William took the safe route, even though pride told him not to. He returned the kit, kept every email, and saved shipping proof. He switched to purchases through a licensed dealer when possible. He also asked a lawyer what possession and constructive possession can mean. That consult cost $310 and saved him from a possible $7,980 mess. Now he warns friends to avoid anything marketed as loopholed or untraceable. Real quick, if you're getting value from this, hit the like button. The algorithm pushes videos with strong like signals to more viewers. That means more responsible owners learn this before it's too late. It takes 2 seconds, so like the video right now. Now we're moving from anger into hope, because you do have control. You can't control headlines, and you can't control internet panic cycles, but you can control your choices, your documentation, and your risk exposure. The goal is staying legal, calm, and prepared if questions ever come. And that starts with knowing the two big battlefields: history tests and text. When a case is about rights, judges compare the burden and purpose. They ask, does this look like older safety rules in spirit and scope? When a case is about statutes, judges ask, do the words allow this? Sometimes the court never even reaches the rights question at all, so you must think like a practical adult, not a comment section warrior. Let me tell you about Nancy. She's 70 years old and lives in Austin, Texas. She's a caregiver for her sister and keeps protection in the home. One morning, she got a call claiming she was flagged in a database. The caller demanded $3,650 for processing to clear her record. Nancy felt fear first, because the caller used official-sounding language. He referenced a court number that sounded real, and she almost believed him. Then he threatened immediate action, and her throat went dry. She asked for a mailed notice, and he refused with a sharp tone. That refusal flipped her fear into anger because it smelled like a scam. The scam got uglier, and it became a time pressure game. The caller said deputies could arrive within hours if she didn't comply. He demanded payment by gift cards, then shifted to wire transfers. Nancy heard a second voice jump in, pretending to be a supervisor. They raised the demand to $5,140 and threatened to freeze her accounts. Nancy felt desperate, but she remembered one rule: slow down under pressure. Nancy hung up and did something simple that changed everything. She called her county clerk directly using a number from the official website. The clerk confirmed there was no such case and no such fee. Nancy reported the scam, warned neighbors, and locked down her accounts. She didn't lose $5,140 and she kept her dignity intact. Now she tells you, real officials mail notices and real threats don't need gift cards. Think of someone who needs this information today. A parent, a friend, a neighbor, or the quiet guy at your range. Someone who could lose money or freedom because they missed one update. Share this video with them now, before you forget later. Text the link right now, because prevention beats regret every single time. Now let's put everything together in plain, useful terms. The Supreme Court is shaping a system where details decide outcomes. If someone is found to be a real, credible threat, limits can happen. If someone is peaceful, broad rules can face tougher questions. And if an agency tries to stretch words beyond a statute, courts may push back. But here's the warning you must carry with you. You can't assume every gun issue is solved by rights arguments alone. Sometimes it's a technical reading of a law's definitions and scope. That means elections matter, legislatures matter, and the text of statutes matters. If you don't like a rule, the remedy might be Congress, not just courts. It also means you should avoid fuzzy categories whenever you can. Fuzzy categories create maybe zones, and maybe zones create prosecutions. If you can choose between a clear legal path and a clever one, choose clear. Clever feels good until it's used against you by someone with power. Your job is to stay boring, lawful, and documented, even when it's annoying. Here's exactly what you need to do. I'm giving you 5 steps, and each one is simple and specific. You don't need to do everything today, but start with step 1. Write these down on paper, because stress makes people forget details. If you do these steps, you reduce risk and increase control. Ready? Let's begin with step 1 this week. Step 1. Pull your own court paperwork history, even if you think it's irrelevant. Search your county clerk website or call the clerk using a verified number. Ask for copies of any protective orders, modifications, or dismissals tied to you. When you call, say, "I need certified copies and service records for my file." This helps you spot hidden findings and dates that can change legal status. Do it within 7 days, because waiting turns small problems into emergencies. Step 2. Stop relying on rumors about legal now versus illegal tomorrow items. Look up your state statute language and read the definition section slowly. If you can't understand it, that's your signal to seek clarification. When you ask a professional, say, "Does this fit the statutory definition as written?" This focuses the discussion on text, not vibes, politics, or internet drama. Set a reminder to recheck yearly, because definitions can shift quietly. Step 3. Create a simple proof folder for ownership and compliance documentation. Include receipts, serial numbers when applicable, transfer records, and training certificates. Add screenshots of official FAQs, but save the page link and access date. If questioned, you can say, "I keep records to stay compliant and responsible." This won't solve everything, but it helps show good faith and reduces confusion. Start this weekend, because building it later feels impossible under stress. Step 4. Avoid any purchase that depends on ambiguity to feel safe. If a seller markets something as a workaround, treat that as a red flag. Choose regulated mainstream channels like licensed dealers whenever possible. If you build or modify, ask, "Could this be seen as readily convertible?" If the answer is unclear, pause and get written guidance from counsel. Make this choice now, because prosecutors love products sold with wink-wink language. Step 5. Plan your response if you're ever questioned by an official. Stay calm, keep your hands visible, and don't argue roadside legal theory. Ask, "Am I being detained, and what is the reason for this stop?" If questions turn legal, say, "I'd like to speak with my attorney first." Then stop talking, because extra words create misunderstandings that can't be undone. Practice that script today, because stress steals your voice when it counts. Let's review what we covered today. You learned how Supreme Court shifts change the tests lower courts must follow. You learned why definitions and statutory text can matter as much as rights talk. You saw how paperwork, hearings, and findings can change possession risk quickly. You heard how scams and agency changes can create sudden financial and legal danger. This affects millions of owners across many states, not just a rare headline case. You now have information worth thousands, so use it like your future depends on it. One final punch you need to remember is this. Confusion is not protection, and silence is not safety. If you assume nobody will care, you're betting on the best day ever. But law enforcement encounters often happen on the worst day of your life. A calm plan and clean documentation can change everything in that moment. And the sooner you get organized, the less fear controls your decisions. If this helped, here's what to do next. Subscribe so you catch the next update before it hits your community. Share this with someone who needs it, especially newer or older owners. comment your state or your situation below, and I read comments when I can. Your engagement helps this reach people who feel lost and overwhelmed, and staying informed is how you protect your freedom without living in panic. Thanks for being here, and stay safe, steady, and smart this week. Important disclaimer: this video is educational only, not legal, financial, tax, or medical advice. Every situation differs and laws vary by state, county, and local policy. Consult licensed professionals like attorneys, CPAs, financial advisors, or doctors before acting. What works for one person may not work for another, even with similar facts. If you're facing a legal risk, get qualified help immediately and follow their guidance.